we take.
You may think what's happening across this country, like Scott Walker's efforts in Wisconsin, to strip rights from working people and give multi-billion-dollar tax breaks to corporations is something new. It's not. It actually was started more than 100 years ago by the stroke of one man's pen. His name was John Chandler Bancroft Davis. I tell his story in the first chapter of my book, Unequal Protection. In 1886, Bancroft was the court reporter for the United States Supreme Court. And he was on the job while that court was hearing arguments in a case called Santa Clara County versus the Southern Pacific Railroad. Although at the time, the Chief Justice, Morrison R. McWait, thought it was just about a simple, boring tax issue, that case would ultimately redefine America forever. If it wasn't for that case, Scott Walker wouldn't even be governor now, because corporate money couldn't have helped him get elected. The case centered on whether or not the corporation, the Southern Pacific Railroad, owed Santa Clara money, 6 years' worth of unpaid property taxes. Again, just all really mundane tax stuff. Ultimately, the court let stand a lower California court decision because they said it was the state of California's issue, not a federal issue. Case closed. Not a constitutional debate. You can read it online on the website of the Supreme Court itself. Nothing there about corporations being able to elect governors. But here's where everything went a little crazy. As one of its 6 defenses in the case, the Southern Pacific Railroad made an unusual argument. They tried to argue that personhood rights under the 14th Amendment, passed just 20 years earlier after the Civil War to grant slaves full citizenship and equal protection under the law, that those rights should also apply to corporations. Why? Because corporations had always been called artificial persons under the law, while humans had always been called natural persons. And the 14th Amendment only says to any person. So the railroad said that to tax them differently in one county than in another was the same as saying that a black person could be free in the North but a slave in the South. In this case, Chief Justice Waite explicitly told the lawyers for the Southern Pacific Railroad that his court would not rule on the issue of corporate personhood, and they ought to move on with their arguments. But a year later, the Chief Justice was mortally ill with congestive heart failure after the case was decided. And the case, as I said, did not decide that corporations have rights as persons. And the court reporter, J.C. Bancroft Davis, was a very wealthy and powerful man, son of the former governor of Massachusetts, former president of the Newburgh and New York Railroad, and apparently good buddies with all the other railroad millionaires. Keep in mind, at that time, these guys were the Bill Gateses of their day. They were literally the richest men in the world. Now, one of the things that Supreme Court reporters do, in addition to chronicling the case, is to write a Cliff Notes version of the case. This short summary has no legal standing whatsoever. It's just there to make it easier for lawyers to find in the future when they're looking for a case. It's called a head note. But bizarrely in this case, Mr. Davis, the clerk, decided to take a bit of poetic license in his head note. While the case did not decide that corporations are persons, in fact, if anything, it rejected the notion for the 5th time in as many years, Bancroft, in his Cliff Notes version, in his head note, he wrote, quote, "The defendant corporations are persons within the intent of the clause in Section 1 of the 14th Amendment of the Constitution of the United States, which forbids a state to deny to any person within its jurisdiction the equal protection of the law," end quote. And with that simple head note, something that isn't legally even binding, Bancroft, the court reporter, not a judge, not an elected official, slipped into the Supreme Court's record full constitutional rights, personhood for corporations. This despite the fact that the Chief Justice specifically said his court would not address the matter, and despite the fact that every previous Supreme Court decision had explicitly denied those same rights to corporations. And by the time John Chandler Bancroft Davis published that head note a year later for the world to see, Chief Justice Waite was dead. But so he couldn't object. But Bancroft's single sentence in that head note that has no legal authority has enabled corporations to use personhood claims to constitutional rights to wage war against unions, against the middle class, and even against our politicians that they don't like, for over 120 years, culminating in the Citizens United decision before the Supreme Court in 2010. And with the help of Republicans like Scott Walker all around the country, these corporations are now claiming the absolute right to buy and sell politicians and to write laws that benefit them and screw you and me. Scott Walker may be the face of this effort today, but the first culprit was that rather obscure court reporter, J.C. Bancroft Davis, who with the stroke of his quill undid the intentions of our founders and set the nation down the road to corporatocracy. Please help us spread the truth about what really happened in that fateful court case in 1886 and to put an end to corporate personhood and thus stop this ruthless takeover of our democracy.
And that's the big picture for tonight, Wednesday, August 1st, 2012.